Hello friends, welcome to my channel. Today I am going to deal with the Industrial Employment Standing Orders Act 1946. Section 1 of the Act provides the application of the Act. The Act shall apply to every industrial establishment situated within the Indian Union except the state of Jammu and Kashmir. So, we are reading the application of the Act. So, first thing is that there are 2 points are there. The first condition is that it shall apply to all industrial establishment situated within the Indian Union. That means within the territory of India, except the state of Jammu and Kashmir. Then the point 2 is that second condition is that it shall apply to all industrial establishment and employing 100 or more workmen. That means that particular industrial establishment must employ 100 or more workmen. It cannot be less than 100 workmen. It must be either 100 or more than 100 on any day of the preceding 12 months, and the time period is in any day of the preceding 12 months. If any industrial establishment on any day preceding 12 months employs in that establishment 100 or more workmen, then within the Indian Union, that means within the territory of India, but it shall not include the state of Jammu and Kashmir, but not in the state of Jammu and Kashmir, then that industrial establishment, the Act shall be applicable to that industrial establishment. However, this is the general rule, but there is an exception is also there. The exception is the power is given to the appropriate government. The appropriate government may be central government or the state government, and the definition of appropriate government is provided under section 2B of the Act, which we'll read later. So the appropriate government, this is the authority which can do so. Appropriate government, it is central government or the state government. The procedure is that notification in the official gazette. By issuing notification in the official gazette may apply the provision of this act to any industrial establishment employing just number of persons as specified in the notification. That means the number of employees fixed by the government may be less than 100 as well. But the appropriate government must give 2 months prior notice of its intentions to make any extension of the act. So the appropriate government has power to extend the provision of this act. The appropriate government has the power to extend the provision of this act to any industrial establishment in which the number of workmen may be less than 100 even, but for this proposed you have to follow a procedure. That's very simple. By issuing a notification in the official gazette and by specifying the number of persons which may be employed in the establishment, and the number of persons even may be less than 100, and they must have to give 2 months prior notice of their intention to do so. This is the procedure. Notification in the official gazette, 2 months prior notice. Then it provides that the act does not apply to the following establishment to which this acts. Then section 2 of the act provides various interpretation, that means definitions. So first of all, we are going to read the definition of appellate authority. Section 2A provides the definition of appellate authority. 2A because A, this is A, that's why appellate authority. Appellate authority means an authority appointed by the appropriate government. Appellate authority means a kind of authority, and the authority shall be appointed by the appropriate government. The procedure is by notification in the official gazette. To exercise in such areas may be specified in the notification the functions of an appellate authority under this act. The appellate authority shall exercise the functions of appellate authority under this act. Appointment shall be made by appropriate government. It may be state government or the central government. Then section 2B provides the definition of appropriate government. It provides that the central government is deemed to be appropriate government in respect of the following industrial establishments. Number 1, in those cases the central government shall be the appropriate government. An establishment under the control of central government. This is obvious thing. If the establishment is under the control of the central government, then the central government shall be appropriate government and the central government shall exercise the powers thereof. But the second thing is railway administration. These are under the central government. That's why the appropriate government shall be central government. And establishment in a major port, mine and oil field. These are in those cases the appropriate government in the central government, and in any other cases the appropriate government shall be state government. Except those cases, all other cases the appropriate government shall be state government. We just need to remember these 3 points. First of all, under the control of central government. Second is railway administration. Third is establishment in a major port, mine, oil field. So, provision added by Amendment Act of 1982 provides that where any question arises as to whether an industrial establishment is under the control of the central government, as we find the industrial establishments which are under the control of the central government, the appropriate government for this purpose shall be the central government. But if any question arises as to whether a particular industrial establishment is under the control of central government or not, then the question shall be referred to the central government, of course, but it can be the government may either on a reference made to it by the employer or the workman. The employer may make the reference to the government, or the workman may make, or any trade union or other representative body of the workman may also make, or even in its own motion shall decide the question. And for this purpose, he have to give the parties an opportunity of being heard also. Decide the question and such decision shall be final and binding on the parties. The procedure is simple. The question shall be referred to the question shall be decided by the central government. It shall be even referred to the central government. But who can refer this? First of all, the employer can refer, the workman, trade union, other representative body of the workmen, or the central government may in its own motion decide the question. But for this purpose, you have to give all the parties mentioned here an opportunity of being heard, and thereafter he shall decide whether the central government shall decide whether the particular industry is under the control of central government or not. So the power to decide has been vested in the central government, and this was the provision was added by Amendment Act of 1982. The act was enacted in 1946. So this is 1982 amendment. Then section 6 provides a definition of certifying officer. The following are said to be the certifying officers under this act. Number 1, certifying officers. What are certifying officers? Labor Commissioner, LC. Regional Labor Commissioner, RLC. This is for a particular reason. That's a Regional Labor Commissioner, or any other officer appointed by the appropriate government by notification in the official gazette. Authority is appropriate government. Procedure is notification in the official gazette to perform all or any of the functions of a certifying officer under this act. So this point is also simple. We need to remember just 3 points. As regards to certifying officer, he shall be a certifying officer under this act may be a Labor Commissioner, LC, RLC, Regional Labor Commissioner, Regional Labor Commissioner, or any other person appointed by appropriate government by notification in the official gazette to perform all or any of the functions of a certifying officer under this act. Any other person who may be appointed by the appropriate government. Procedure is notification in the official gazette. Then section 2D provides the definition of employer, which is also very important. The expression employer means the owner of an industrial establishment to which this act for the time being applies. It also includes. So first thing is that the employer is a person who is the owner of an industrial establishment. So there is an industrial establishment. So who shall be the employer? The owner. The person who owns the establishment shall be the general rule is that generally shall be the employer, because he has the power to employ workmen. But at the same time, it also includes in a factory any person named under clause A of subsection 1 of section 7 of the Factories Act 1948 as manager of the factory. In case of factory, the manager of the factory can be an employer, manager himself. So any person, the person may be appointed under clause F of subsection 1 of section 7 of Factories Act 1948. So here the reference has been made to the Factories Act 1948 in a particular section 7 subsection 1 clause F. Then comes 2, in an industrial establishment. In case of an industrial establishment, in point 1 we have read about a factory. Point 2, we are going to read about industrial establishment. In an industrial establishment under the control of any department of any government of India, if the industrial establishment is under the control of any department of the government of India, the authority appointed by such government, in this behalf or where no authority is appointed, the head of the department shall be the what? Employer. So if the industrial establishment is under, point 2 says that if there is an industrial establishment, the industrial establishment is under the control of the GOI, Government of India. So who shall be the employer? The Government of India shall appoint a authority, or either the authority, if the Government of India appoints any authority for that purpose, then the authority shall be the employer. And if the government or in any other cases, if no authority is appointed, then the head of the department, HOD, shall be the employer. That's all. In case if the industrial establishment is under the control of the Department of Government of India. Then comes point 3. It is about in any other industrial establishment. The word any other is used here. That means it excludes point 2 and point 3. Point 2 and point 1. In any other industrial establishment, any person responsible to the owner for the supervision, any person can be the employer. The person who is responsible to the owner, the person who is responsible to the owner for the supervision and control of the industrial establishment. So for example, there is an industrial establishment, there is a person who is entrusted with the supervision and control of the industrial establishment by the owner. So the owner directly shall not be the employer, but the person who is entrusted with the supervision and control of the establishment shall be the person who will employ the workman. So he shall be the employer, not the owner. So as regards to the definition of employer is provided under section 2D of the Act. It contains 3 points. In case of factory it is different. In case of industrial establishment, GOI, we have to remember these 3 points. Then section 2E provides the definition of industrial establishment. We have read previously under section 2D industrial establishment. Right, the industrial establishment word is there, but we need to understand what does it mean by industrial establishment as per provided under section 2E of the Act. So the expression industrial establishment means 4 points are there. Point 1 says this: an industrial establishment is defined in clause 2 of section 2 of the Payment of Wages Act 1936. So point 1 refers to the Payment of Wages Act 1936, and the section referred here is of course section 2, because mainly definitions are generally in most of the legislations or acts, the definitions provided in section 2. So it is section 2 of course. Then section 2 clause 2 of Payment of Wages Act 1936. The industrial establishment defined in clause 2 of section 2 of Payment of Wages Act 1936 is the industrial establishment. Then comes in a factory. Then comes 2. A factory is defined in clause M. In case of a factory, industrial establishment will include industrial establishment defined under this particular section of Payment of Wages Act 1936, as well as it will include a factory as defined under clause M of section 2 of Factories Act 1948, as well as it will include a railway as defined under clause 4 of section 2 of the Indian Railways Act 1980. This is clause M. Okay, we know the act. Factories Act 1948. We have to read it. So this is section 2. Again, same thing as in the India Case of Payment of Wages Act also, but the clause is different. Here it is clause M. We have to remember clause M. Factories Act 1948. Then point 3 says that Indian Railways Act, any railway is defined under clause 4 of section 2. Again section 2. Indian Railways Act 1890. The year is 1890, not 1990 or something like this. 1890. Very old legislation. And section 2 clause 4. Then point 4 provides the establishment of a person who for the purpose of fulfilling a contract with the owner of an industrial establishment employs workmen. Then section 2F provides the definition of prescribe, which is not important. We're going to read section 2G, which provides the definition of standing orders. It's very important. The expression standing order means rules relating to matters set out in the schedule of the act. Standing order means what? First thing is rules. Rules relating to what kind of matters? The matters which are set out in the schedule of this act. So the rules relating to the matters, set out in the schedule of this act. The following matters should, according to the schedule, be provided in standing orders under this act. What are those matters? Number 1 is classification of workmen. Classification, okay? Workmen, dividing workmen into various classes. This is what called classification of workmen. The classes may be whether permanent, whether a particular workman is permanent or temporary, whether he is working permanently or temporarily, or apprentice, or probationers, or budlies, etc. These are the types of workmen. So this is the matter, first matter. Classification of workmen. Example, whether permanent, temporary, apprentice, probationers, or budlies. Then comes point 2, manner or of intimation to workmen, periods and hours of work. Holidays, per days, and wage rates, etc. Manner of intimation. How to intimate to the workmen as regards to the periods and hours of work. Holidays, per days, wage rate, what is the rate, what may be the rate of the wages, and the holidays, all these matters. This is also important. And shift working. Shift working, in which shift which workman will work and in what manner. So these are the matters. Then comes attendance and late coming. First of all, attendance is very important. It's very important to maintain a register and attendance. And late coming, if someone comes lately, then what will happen with him? Then comes the 5 conditions of procedure in applying for the authority which may grant leave and holidays. Condition of procedure in applying for what? Applying for leave and holiday. So what are the conditions for it, and what are the procedures to be followed for it, and the authority to whom it is to be an application to be given. So these are the things which may grant leave and holidays. 5. Then 6 is requirement to enter premises by certain grants and liability to charge. So there may be in under an establishment some requirements to enter to the premises, that means the building itself, by certain gates, gate 1, gate 2, gate 3, and what are the requirements to enter by those gates, and liability to charge. Then comes 7, closing and reopening of sections of the industrial establishment and temporary stoppage of work and the rights and liabilities of the employer and workmen arising therefrom. Point 7 says what? Closing and reopening of sections of industrial establishment. An industrial establishment may have some sections. Okay, and closing and reopening of it, and temporary stoppage, if it has been stopped temporarily, of course, of work, and the rights and liabilities of the employer and the workmen arising therefrom. Then comes a termination of employment and the notice thereof to be given by the employer and the workmen. In case of termination of employment, notice is very important, because it is the rule of natural justice and opportunity of being heard. Then comes 9, suspension or dismissal for misconduct. Misconduct means an act contrary to the rules, act or omissions, any kind of act or omissions which constitute misconduct. So they may be suspended or dismissed. So these are some kind of disciplinary actions. So these matters are also covered under standing orders. Then 10, means of redress for workmen against unfair treatment or wrongful means of redress. Redress means kind of remedy. What are the remedies which the workmen may have as regards to unfair treatment or wrongful exactions by the employer or his agent or servant. Then comes 11, any other matter which may be prescribed. So these are the matter, 11 points which we need to remember, of course. Then let's revise it again. First one is classification of workmen. The classification may be as regards to whether it is permanent or not. Then comes temporary, then apprentice, probationers or budlies. So first one is classification. It's C. It's maybe permanent, temporary, CPT, or apprentice or probation, PTAP, or B, budlies. Then comes manner of intimating to workmen, periods and hours of work. Then comes hours of work, hours it is, and then periods and hours of work, periods and hours of work, and holidays, it's 2, per days and wages, holidays, per days and wages. Then comes shift working, shift, night shift, day shift working, then attendance and late coming. This is also easy, it's not tough to remember. Then condition of procedure in applying for an authority which may grant leave and holidays. Then requirement to enter premises by certain gates, liability to charge. certain gates and liability to stores. Then comes closing and reopening of sections of the industrial establishment, and temporary stoppage of work, and the rights and liabilities of employer and workmen arising therefrom. Point 7. 8. Termination of employment and the notice thereof to be given by the employer to workmen. Termination. It deals with termination of employment and the notice. It's very important thereof to be given by the employer to the workmen. Termination and notice. These are the two keywords. Then comes 9. Suspension or dismissal for misconduct. Suspension or dismissal. Either he may be suspended or may be dismissed for misconduct. Then point 9 is about misconduct or acts or omissions which constitute misconduct. 10 is means of redress. Redress means remedy for workmen against unfair treatment or wrongful exactions by the employer or his agent or servant. It may be done by the employer or his agent or the servant. Liabilities are of these three persons: employer, agent, servant. Then comes prescribe. Any other matter which may be prescribed. Total 11 points we have revised. Now it shall be obligatory. Obligatory means mandatory. It is bound to do so upon the employer. That means employer must do it. He cannot escape the liability. That's why it is what called obligatory. Obligatory upon the employer to make provisions in the standing orders. He must have to make provisions in the standing orders regarding those matters as specified in the schedule of the Act. Once a provision is made, it can be modified. Modification is also there. The provisions relating to modification of those or matters only in accordance, but the condition is that it must be done only in accordance with the provisions of section 10 subsection 2 of this Act. So section 10 subsection 2 deals with the provisions relating to modification of those standing orders. Section 10 subsection 2 modification. It's important. The word condition in clause 5 of the schedule has to be interpreted in a broad and liberal sense. That means it should be interpreted it should be given a wider interpretation as opposed to the narrower or some kind of restricted or strict interpretation. These interpretations are not allowed. It should be interpreted liberally. This dictionary meaning of the word condition is a provision or a stipulation. So what is the dictionary meaning of the word condition? It is a kind of provision or a stipulation. Thus, construed conditions of leave and holidays means a provision for the quantum of leave and holidays. Then the expressions termination of employment and notice thereof to be given by the employer to the workman in clause 8 of the schedule. This is clause 8. This is the provision termination of employment and the notice thereof to be given by the employer and the workman are to be read disjunctively. They comprise two distinct but connected matters. These are two distinct matters. One deals with termination of employment, another deals with giving of the notice. Okay, these are two distinct matters, different matters, but they are connected. This is what's said. But connected matters, and the later does not qualify the former. So termination of employment will be the principal or primary subject. Okay, the principal and the primary subject is the termination of employment. But notice thereof, notice and relations thereof from an ancillary or subsidiary subject. That means secondary subject or subsidiary subject. To read the entry as one part qualifying the other will leave a sizable gap in the area which schedule is apparently intended to cover. That means for the purpose of termination, notice is important to give. Then 8 provides the definition of trade union. Trade union means a trade union for the time being registered under the Trade Unions Act 1926. Definition is very simple. Then comes I, wages and workmen. Wages and workmen have the meaning respectively assigned to them in clause RR and S of section 2 of the Industrial Disputes Act 1947. So for the definition of wages and workmen, we can refer Industrial Disputes Act 1947. The special provision for this purpose is clause RR and S of section 2 of Industrial Disputes Act 1947. Therefore, for detailed discussions about the meaning of these two words, reference may be made to the relevant sections of Industrial Disputes Act 1947. In the second part of this video, we will read various case laws. But in this video, we have covered section 1 to section 2. That is, first of all, extent of the Act, its applicability, and also some definitions from section 2A to section 2 I of the Industrial Employment Standing Orders Act 1946. Thank you. Thanks for watching. Please do not forget to subscribe.